imposed by the Texas Civil Practices and Remedies Code. Their deadline to file the affidavits was February 12, 2023. And Your Honor, just to put the plaintiffs on timeliness into perspective, they filed their affidavits 2 years after plaintiff was done treating. His last date of treatment was July 14, 2021. He was done with treatment even before this lawsuit was filed. And furthermore, plaintiff did not seek leave of the court to serve his affidavits. Therefore, the affidavits are inadmissible hearsay and cannot be used to prove the reasonableness and necessity of the medical services. In their response, plaintiff will argue that defendant has not been prejudiced, but that is not the case, Your Honor. Since their deadline had passed and no affidavits were filed, we did not retain an expert. And in his response, he is also asking that the court allow his affidavits and that defendant be given an opportunity to controvert. However, that is too late, Your Honor. We have a trial date of September 5th, 2023, and therefore the defendant would definitely be prejudiced if plaintiff's affidavits were allowed. Therefore, we're asking that his affidavits be stricken since they were filed untimely.
All right, response?
Yes, Your Honor. We're talking about $3,700 in chiropractic care. Defendants received the billing in December of 2022. The exact same billing was given to them in June in an affidavit form. There's no experts on the defense side. If they can find someone that can controvert $3,700, I think they're welcome to do it. I think it's clear from recent case law around 18.001 that this is not designed to be a gotcha statute. This is a way to avoid having medical providers come down to prove up minor amounts, exactly like this. Now, if the court's inclined to have us come to trial on September 5th, that's in the court's discretion. And the alternative I would request, because I presume we're not at the top of this court's docket, because this case is barely over a year old, is that we be given a setting, defendants be given 30 to 45 days to controvert if they wish. And then,
so this is a relatively recent provision, these deadlines, and it doesn't surprise me. I'm kind of surprised I don't see more of these actually, because of the way the deadlines are set up. What is the case law saying about what trial judges should do with these deadlines?
Well, I mean,
the cases, let me know.
Yes, Your Honor. I mean, the best thing to do is to give everyone a deadline, if based on typically around expert discovery. That's what typically I have seen in both practical and in cases. I don't have a specific case that I could cite to you. I could offer. I could research it in more. But I could just tell you I'm experienced, and that's why I think opposing counsel referenced that this wasn't referred to in the scheduling order, because that's a common fix that the courts have. Because on $3,700, this statute's not designed to block, to make me bring someone from a chiropractic facility to prove that amount up. And that's clear in discussion around the Supreme Court before 18.001 was modified. But again, if I don't know if the court plans on having us try this case on September 5th. I don't know what the docket looks like.
I don't know. Let me take a look. We're moving cases. I mean, we're really catching up, and I've tried some 22 cases already. Let me see. That's next week. Right now, you're 1, 2, 3. I think you're fourth on the docket. It looks like.
Yeah.
For some reason, we have a ton of non-juries next week. Some of those Yeah, that's a non-jury. It's not going to go. You might get reached. I don't know anything. The cases ahead of you, I think they're all. Wait a minute. Yeah, they look like they're car wrecks. So, I mean, you could get reached. I mean, Miss Millen, kind of what is your goal here?
Your Honor, like Mr. Giddens said, if the statute is designed, like he said, to not have to bring your providers to come testify at a trial, but if that was his intent, Your Honor, I feel like he had ample time to file these affidavits, and we would have had time to file these counter affidavits as this rule allows.
What case law is there out there interpreting this new section?
Your Honor, off the top of my head, I do not know any names. I could submit something to the court if that's, if you would.
Yeah, I mean, I would like to know what the case law is, because this, I mean, this has got to come up, right? I mean, this is a new provision, and I kind of figured we'd have a ton of these types of motions. I haven't had too many of them. I've had some, but not a whole lot. I mean, I guess what if you guys are, what I think is the practical solution is we just move the trial date, give you a chance to designate, you know, a controverting position or whatever, if you want that. If you don't want to do that, then I'm going to just say you guys got to brief this for me, because I've read the provision. It's I don't know how the courts of appeals are going to interpret this, and so I'd like to. Do you want to do some briefing on this, or do you want to reach an agreement? I guess, Ms. Millen.
Your Honor, I think we would be okay with reaching an agreement.
Okay, and what would you feel comfortable with? Would you be able? We move the trial setting, 4 or 5 months. Would you be willing to?
Yes, Your Honor. I'm sorry, go ahead.
I was going to suggest that it's just an idea. This is not an order. I'm not going to do this unless you agree. Is I would suggest we move this 5 months, and then give you a chance to file controverting affidavits. Maybe give you 60 days or so to file controverting affidavits if you want to. It's not very much money.
Okay.
And then you would draw your motion to strike. If that's what you want to do. If you don't want to do that, then
yes, Your Honor. We could do that if we could get a trial date, like I said, in 4 or 5 months. That works for us.
Mr. Giddens, what do you think?
Your Honor, yeah, that's what I was proposing, because I think it cures the prejudice. 60 days, I think, is definitely enough time for them to do that. If we're looking at 5 months, are you able to tell us what week that would look like for the court docket?
I'm flexible. I mean, I'm going to set you on a week where we don't have a trial setting. We're still pretty packed. That's why the next week is a little bit unusual that you're that high on the docket. I could give you, for example, on January 23rd, we only have 12 cases set. Let me see if we have any big ones that day. What's the cause number on this one again?
That would be DC-22-08250.
So on at least at this point, on January 23rd, you'd be number 2 on the docket as of right now.
Okay.
That'd be great for me.
How does that work for you, Ms. Millen?
That works, Your Honor.
All right, so let's make it clear on the record. Ms. Millen, you've agreed to withdraw your motion to strike and any claims that the plaintiff's billing record affidavits are untimely, at least the ones that have been filed so far. In return, the court is going to reset this trial setting to January 23rd, give you an additional 60 days to file controverting affidavits. Is that agreed to by both parties?
Yes, Your Honor.
Yes, Your Honor.
All right, this will be Rule 11. Okay, anything else we need to talk about, guys?
No, Your Honor.
Do we have a pre-trial docket date?
We don't usually do pre-trials on car wreck cases, so you
Fine with
just,
me.
yeah, we're, maybe I'm old school, I don't know, but I just, most cases, I just do the pre-trial the day of, so.
I like
And
it.
I would expect, things can change, but I would expect you'll probably get called down that day. Just given what's on the docket right now, but again, that can change, so.
Okay.
Have you already been to mediation on this case?
Yes, we have, Your Honor.
Okay. All right, well, great, guys. You have a great rest of your day. And Ron, did you get that? Did you get that we're resetting the case?
Yes, Judge.
Go ahead and reset the case and take it off our docket for next week.
Will do.
Thank
All
you,
right,
Your Honor.
guys, you have a great day.
Bye-bye.
Thank you.